Yes, so thank you all for attending this final webinar in our webinar series related to estate planning. We unfortunately did not get the first one recorded. I am working on finding an older version that we might have recorded, but we've been moving files, so it is taking me a while to track that one down. That one was with Alex Chan, handling family communications and how to get this process started. Last week was Jesse Ketterman talking about health insurance options as you get older. And then today is me talking about some of the tools that will come together in this process. And I am going to go ahead and end the poll. Um, and throughout this process, feel free to put questions in the chat box, and I will try to answer them as we go along, but I'll leave a little bit of time for questions at the end. So get my PowerPoint up. I'm going to end the poll. Okay. So again, thank you all for attending. I'm Paul Goeringer. I'm a principal faculty specialist and extension specialist. I'm located in Ag and Resource Economics. And we're going to talk today about kind of what makes an effective succession plan. And it's you go through this process, a lot of tools will be used. What it's going to depend on how we put these tools together depends a lot on how you're going to operate together with that communication that's gone on before we start this process. University programs are open to all. And then I have a couple of videos to play that hopefully I hit the button and you can hear.
This institution is an equal opportunity provider. This institution is an equal opportunity provider.
Okay.
This institution is an equal opportunity.
And then none of this is legal advice. I hope we're all good with that. I get in the next slide. So let's talk about this. In this process, and you don't have to put in the chat, I just kind of want you to take 30 seconds and think about within the estate planning process as we look at it and succession planning processes, as we think about it with farms, you know, and a farm family, where are you at individually in this process? Have you started it? Are you in the midst of doing it and having issues? Have you not even thought about it? Or do you have a fully effective plan that you're implementing and looking at over time, as we're going to talk about? How do we revise that plan to sort of make it work better over time? So as you think about that, and some of you may get concerned that you haven't done anything yet, as I often like to point out, that's where you're at in the galaxy. We're all going to come at this at different stages, different processes. So it's good that you're here today. We can kind of talk through some of the tools that will be used and start getting that process going for getting you to the point you want to be at. In all of this, the goal is getting you to where you and your family want to go with this. That's going to take a lot of communication with family. There may be other errors involved in this, and thinking about how we're going to get, the farm moved to something that can be passed on to the next generation and potentially the generations after that. A lot of this, and we didn't talk about it in this series, is thinking about how are we going to develop that business plan to make it work? Do we have to add other enterprises into the farm to make it more financially viable for someone to come back and work full time, or are they going to work part time, have an off farm job, do some of that? But what's that going to take to get that done? And then as we look at it too, and what we're going to talk about today is kind of what is that estate plan going to look like? What are the tools that are going to go into this process that you can start thinking about within this? So as we talk about goals, and from doing this for a number of years in Maryland, One of the biggest goals that people tell me they have is you really want to keep the farm in the family. It's been there for, multiple generations, and we want to make sure it's there. It's a viable operation for someone to take over down the road. So, as we're going to look at these tools, and we haven't talked about the tools yet, but I wanted to give this as a primer for us to think about as we go through. What tools are going to work the best for you? And as we go through the next couple of slides, it's really important to start thinking about in this process. Not all these tools are going to be equal. There's really going to be differences between them as we move forward. One thing I often have to point out is if we're not going to have an on-farm heir take over, we're not going to have an on-farm heir come in to take this over. A lot of the tools I'm going to talk about are going to change as I think about this. It's going to be an on-farm heir we're thinking about in this process, but if we don't have that person, what's that going to look like in the end to make that work? And as I tell everybody, I stole this slide from Robert Moore at The Ohio State University. I saw it in a presentation about a year ago and really liked the way he laid it out. So I just kind of duplicated it here for you. So if our goals are to keep the farmland in the family, and we think about tools that will provide us with the ability to do that and ensure, that goal stays as something we want to do. If we look at the left, we have the most least protection out there to the right, which I think that's still the same on your screen. It is on my screen. The right is going to be what's the most protection we can offer to make that goal happen. So as we're going to talk about this with the first set of tools, we really could just transfer it to the heirs with no restrictions. It's typically what we're going to do in a will. We're going to deed it to them over to them in the will. That's going to be out there. There are no restrictions on that. There's no guarantees that farmland will stay in the family. If we're looking at an operation where we may have to divide it up to give to multiple children and one's going to stay on the farm, what's the guarantees that that person staying on the farm to work is actually going to have access to that land? If other family members have goals to sell and, turn it into cash, there's nothing really within that to stop it. We could look at agricultural and conservation easements if we keep moving to the right. Those are going to keep the farm in farmland, but there are no guarantees it's going to stay with that family. So we get a little bit more clever in the will and move a little bit further to the right, the next two. We could set up within the will that however it's deeded to the next generation, if we're giving it to heirs who are not going to be on the farm, we could add in rights of first refusal for the on-farm heir to take and to exercise. If that farmland ever comes up for sale, they have the right of first refusal to buy it. We could set it up with long-term leases so it's guaranteed that they get access to that property to keep farming. The issues with that are, what happens if they can't come up with the cash or get the financing to buy that piece of property back for the farm? So there's some ability to protect the farmland, but not that much. Long-term leases, another way to tie it up. There's guarantee they're going to get the farmland, but not a guarantee it's going to stay in the family as something the family owns. As we move further and further to the right, we have LLCs. We can move the land into an LLC that's controlled by the family. That sort of limits the ability, that includes limits on the ability of the family to dispose of the property in certain ways. It really does become a decision of the business to make that decision, and we can kind of figure out who's going to have that right to make that decision. Is it going to be all the heirs, or is it only going to be those on the farm? And the other heirs are just participating in the business with no real ability to make decisions on selling assets. The final one we can look at, and we'll talk about this a little bit with trust, is then if we really want to get into this, when we look at what to do. We really could set up a trust that restricts the sale of the land in any way outside the family. So that's some of the ways to think about this as we think about the tools as we're moving forward. And again, if you have questions, feel free to put them in the chat box at any time. So, what do you got to do to start developing an estate plan? So, as I like to point out, and these stats are pretty much up to date, um, this year's have not come out yet. If we look at it from a standpoint of who has not developed a will, well, 45% of all Americans 55 or older do not have an estate plan. 55% do, but 45% do not, as I often point out in this, and none of you can really chime in and talk. Oh, I see a question in the chat box. I see a question. Do I have an example of precedents or trust or LLCs that have been implemented that can work? I believe I do. I will get back with you after this webinar. Um, and then if we look at all Americans, 55% do not have an estate plan. Going back to that first bullet point, if we got 45% of 55 or older do not have an estate plan, what happens as we age? We have abilities to where we may have dementia, Alzheimer's, other health issues may come into effect that make it harder and harder for us to do an estate plan, as we're going to talk about throughout this process. And with 55% of Americans not having an estate plan, if we go back 5 years, well, 6 years ago this year, to when COVID was going through and we had a lot of people in hospitals, um, and lots of concern you might end up in a hospital with something happening to you. Um, we had a number of cases where people were looking at wills, but if you looked at the survey results from the next year, they were pretty much even with this. This really doesn't change all that much. It goes up 1% or 2 each year or down 1% or 2, but it really does stay about the same. COVID did not change it in any way. So we're looking at developing an estate plan. What are we going to do? Well, if we've got children under 18, we really have to think about how we're going to set that up to take care of those children. Who's going to be the person doing it? There's a commercial on television some of you may have seen, for an online company that will assist with this, where a couple is driving and talking about, well, if something happens to us, this person will get our children. And then the nice person comes in and says, nope, not going to work that way. You actually have to go out and do all this other stuff to make it happen. This is the other way to make that actually happen and have legal effect. You have to develop an estate plan that's going to lay out who's going to take care of those minor children. We're going to have instruments that we're going to talk about here in a minute. We're going to designate beneficiaries on those. We're going to lay out that if something happens to you, this account goes to this person, this policy goes to this person, this retirement account goes to this person. We're going to have powers of attorney set up and all that. Typically, we're going to do it with business and healthcare. They're going to be separated out within all that. This is going to be the person that's going to make decisions for you in those cases when something happens to you and you become incapacitated and cannot do that. We'll talk about this a little bit later. You're going to do an advanced healthcare directive as well, also known as a living will, that will lay out all the ways you would like to be resuscitated or not resuscitated in certain situations, and what life sustaining care do you actually want to receive. We're going to have you do a will, even though I just pointed out on that other slide that wills are really bad at doing some of the stuff we need it to do to protect farmland. We're still going to have you do a will because you're going to have other property that probably needs to be distributed outside of the farm that needs to be taken care of, and a will do that. You may end up with a trust in some of that as well, depending on what you want to do. We'll talk about trust here in a minute. There may be life insurance. involved in this. Going back to the designating beneficiaries, we may have already have life insurance and designated that, but we may have to look at, do we want to buy life insurance if we can still buy coverage, because this may be a way to equalize out payments from an on-farm heir to an off-farm heir. And feel free to put this in the chat, but why do I have these famous people up here? If we want to go from top left across the top and down the bottom, we have Sonny Bono, Prince, Amy Winehouse, and Aretha Franklin. Anyone want to type in a box why I put these folks in there? Yep, they
Did
all
they die
died.
young?
They all died. Yep. Well, some died. Sonny Bono was in his
Wait, isn't
60s.
Aretha still alive?
No, Aretha passed away.
Oh, damn.
Aretha is gone, but they all died without an estate plan.
Mm.
Um, Now, as everyone, when I do this, points out to me, Amy Winehouse was 28 or something like that. She was in her 20s when she passed away. She probably was not thinking about an estate plan. Um, Put up there. Sonny Bono, I think, was in his 60s when he passed away. Prince was in his 50s. And I think Aretha was in her 70s when she passed away. As I often point out, does anybody know how Aretha Franklin got paid for concerts? Cash up front, and it was in her purse where she could see it on the stage. Aretha had been cheated over the years and didn't trust a lot of people, so she may have not trusted lawyers to write her estate plan. Um, Black Panther, Chadwick Boseman, had cancer, knew he was dying, also, and had small children, also died without an estate plan. So it can happen to anybody. So what happens if you die without an estate plan? And I will explain why Snoop is up here in a second, because Snoop is still alive, um, and periodically makes appearances at the Olympics every 2 years, depending on winter or summer. So if you die without an estate plan, you're known to have died intestate. State laws govern how your property is being distributed. I did not play the video today that I normally play because they would get this video taken down off YouTube because I would have violated allegedly copyright law as a part of that. But in it, we go through a character in a TV show working through this where they keep telling him his property will go to the government. Your property will not go to the government if you die without an estate plan. Anyone who dies intestate, basically the way it is set up, is your property is then divided up among your family members, regardless of your relationship that you had with your family. The basic idea with most state laws, and these vary from state to state, is about 50 to 51% of your estate will go to your surviving spouse if you had a spouse, and then the other property will be divided up among any children you might have had, and if there are no children, it may get divided up among siblings and your parents if they're still alive. So it can all freely depend on just the relationship. I point out it doesn't matter the relationship. We have a number of cases out there where a couple in the middle of a divorce is one of them passes away in the middle, dies without an estate plan. Well, the soon to be ex spouse just got 51% of the estate because there's really no way to stop that until the divorce happens. So we have to point out to people again that if you want to do this and want to stop certain things, you have to have a will. Point out also, it doesn't matter on relationships with children. If there is no will, the children will all get something equally, depending, regardless of the relationship. Now, for why Snoop Dogg is up there, now that I think I have all of Snoop's children on this photo. Snoop Dogg was famous for, in an interview a couple of years ago, saying he did not want to have an estate plan. He wanted to be reincarnated as a butterfly and watch his children fight over his estate. That probably could potentially happen, but for the most part, intestacy law is going to divide it up with few problems. There might be some disputes over who gets what, but it's all going to be divided up based on value in the end. The way to prevent all this is just have a will. Who can make a will? I love this quote from the Arkansas Supreme Court. You don't have to be a genius, a high school graduate, a college graduate, or even attended grade school to make a will. All you got to be is over 18 years old and have a sound mind. What does sound mind mean? It means when you go into the lawyer's office, we're going to ask you some basic questions to make sure, you know, you kind of know who your family is, who your children are, if you have children, and sort of understand that you understand what property you own is. I point this out to everyone. The issue becomes as we see with the figures, if we're doing this as we age and getting later in life, we may not always have a sound mind. And sound mind only means on that day when you walked into the attorney's office, you were able to answer the questions that you were able to answer. It may have been your best day of mental clarity ever when you walked in and you were able to answer the questions. The other thing I have to point out in this, because I have a number of friends that do this around the country for clients, is when we have an older person come in, um, typically, depending on age, they may be driven by a child in or another family member in. If we're going to do this and figure out if they have sound mind, guess who's leaving the room first? The person that brought them there. Why? Because we all have this tendency. If someone is struggling to answer a question, what do? You either attempt to help them answer the question or answer it for them. So we will not want that person in the room prompting them. We will want them to be fully doing this on their own. And as I often point out, even though I've told you it's the least likely thing to protect your farmland, you still need this tool. And it's the one tool that you're going to have regardless of what you pick. A couple more things on wills. We can have this idea of a holographic will. These are wills that are written entirely in your handwriting. If we're doing a will, and for those that have done wills in the room, um, when you did it, it was properly witnessed, which typically means we're going to go into a room, we're going to sit around the table. It's going to be you, the attorney, and whoever else is doing a will with you that day. If it's a spouse, we're probably going to be have two people signing wills. And then we're going to bring two people into the room to witness you sign all at one time. This is all done at the same time. We do not take it outside the room and walk around and have people do it. It's all in the same room. You're going to go in, you're going to say, "This is my last will and testament," and some other words you have to say to make all this legal for the process. You're going to sign the document. The witnesses are going to go in and sign it. And in many states, there's going to be a notary in the room who will also witness all this and then notarize a document on the back to help make the will more authentic when it goes in. The reason we go through this whole entire ceremony is the one person we need the day this goes to court to tell us this is your actual will is you, and you're not going to be there that day. So we take these to a higher standard and want everything done in a room together with stuff. Holographic wills are the exception to all this. You can see on the right, I didn't put a weird picture in here. I actually put an image of a holographic will. It's written entirely in your handwriting. You cannot at any point type this out. It has to be 100% written in your handwriting, and it's signed and dated at the bottom by you. I went through all that to just tell you the one sad fact. In Maryland, these are not valid wills. They are only valid in the case of members of the armed services, and they have to be signed outside the United States, and they're void 1 year after discharge. Why? Well, if we think about that through, they're in the armed services, they're outside the US, they may be in a war zone. We don't want that to prevent them from being able to make a will if something could happen to them. So we allow those in those cases. In Maryland, for everyone else, you got to go to an attorney's office and get it done. At any point, you can change this document. You can amend it have the attorney add amendments into it. You can draft a codicil, which is just an amendment to the will and amends the earlier draft, or you can write a whole new will. All of this has to meet the same requirements. So every time we do it, you go back through, have it witnessed, go through the whole signing ceremony again. As I point out to everybody, margin notes do not count. You can't cross somebody's name out. You can't do anything to change the actual document's effect until you go in and get it drafted again, amended, or a codicil drafted in some way. The reason, again, goes back to what I said earlier. The time we need to figure out what this document says and means, you're no longer here. You can't tell us if you actually crossed it out or one of the children just decided to have fun that day and crossed somebody's name out so they got something that they weren't supposed to get. So there's a whole process involved in this. It can be costly if we have to change these a lot. And we'll go to probate here in a minute, but I want to talk about the stuff outside of probate. We're going to have a lot of property that's really going to transfer outside the will. That's going to be the stuff you set the beneficiaries up for. You may have life insurance policies. You've already selected who that's going to be. I don't have retirement accounts on here. Your retirement account may have a beneficiary associated with it. We're going to have payable on death bank accounts where you've already selected that person. That account goes to upon your death. Um, if you're married or have business partners or working with the children in some way, you may have a joint bank account. Those are already set up to be managed by the other party if something happens to you. With real property, we may have real property held either as joint tenants with rights of survivorship or joint or tenancy by the entirety. If it's tenancy by the entirety, it's the same thing as a joint tenancy with the rights of survivorship. Um, Depending on how many joint tenants there are, once one joint tenant passes away, the property just goes, their interest goes to the remaining joint tenants till we have one person left who can then deed that property to somebody. Okay, one last thing to talk about before we get to some of the probate things and tax issues. Okay, we can have a trust. And before we start with trust, I often like to point out, unlike wills, they may not be for everybody. They're going to add a little bit of complexity in asset management, but like I talked about at start, they're really going to provide you with a vessel. If your goal is to keep the farm in the family, we can really set it up in a way that will limit that ability to sell the property. As I talk to folks a lot about this, and one of the biggest things we've gotten out of this round of estate planning workshops is we really need to do some workshops and much more in-depth stuff on trust through this. And if you go to agrisk.umd.edu, and I can put that in the chat, I forgot to get the link up while I was doing it. We have some trusts, at least a couple of publications on trust up there. If you just search trust, it should come up. One of the reasons we might want to consider doing this is we might be over the estate tax limit. For federal estate tax purposes, it's $15 million for an individual, $30 million for a couple, a married couple. For that, for Maryland in estate taxes, it's 5 million for an individual, 10 million for a couple, and we'll talk about some of the ag things that can exist in that here in a minute. We may want to do them for disabled children, a disabled family member, someone, so we know, or just for children, so we know somebody money is there to take care of them if parents unexpectedly pass away. Um, or we may want to have them for family members. They may be set up because family members anticipate, it may not happen, it may happen. They may no longer be able to manage their own affairs. So then there's a vessel that we can manage that a little bit easier. And one of the things I forgot to say before I started typing in the chat is with a lot of these, when you work with the attorney, they can kind of set up the rules that are going to dictate with all that. And that's what we're looking at how to do in this hopefully the next series of workshops we do is having some attorneys come in and talk about how trusts are set up and some of the different ways we can make them work in some of the unique farm situations that happen. We could just set this up in a will. It's called the testamentary trust. Um, Typically, we'll do that when we have to deal with a minor child or a disabled family member that needs to be taken care of. We'll do it that way and not have a separate document for it. Um, the biggest way people do this right now is they set up living trust. So it's set up during your lifetime. You're pretty much the trustor, the trustee, and the beneficiary during your lifetime. And it continues on until your death. We're going to talk about probate here in a minute, but it's typically the easiest way most folks use to avoid the probate process. Throughout the course of your lifetime, if it's set up this way, the trust is revocable. You retain the full control to change this trust however you want to during the course of your lifetime. You can even get rid of the trust if you want to. Once you pass away, the trust becomes irrevocable. And anything in it is permanent, and there is no power to change the trust until we hit the event that would dissolve the trust. And in some cases, that may be some of these were set up for estate tax avoidance issues. When the estate tax was low, some of it could be it was generation skipping. So the generation that took control after the parents passed away may have no control, but the grandkids would have control at that point to change the trust, dissolve the trust, and get rid of it. Why do we want to do this? Well, we're going to look at it in a lot of cases because it's going to avoid probate costs. Probate costs are a percent of the estate, so we take into account all of the property that's going to have to go through probate outside the property that doesn't go through probate, and we come up with a percent of that. It's going to be used to pay the court and the attorneys for that. If we have property in multiple states, it's going to be an easy way to transfer property to where we don't have to go through probate in multiple states. If something happens to you, we have a better vessel to manage assets for you when something happens and you can't make those decisions anymore. And then it distributes property much faster. As I point out to everybody, if we're this morbid, we could literally have the funeral in the morning and be outside later that afternoon dividing property up. It's that quick. We don't have to go through probate. Why might not we want to do this? They are expensive to set up. As I tell everybody, especially if we're going to go into that ability to limit transfer of farmland, we're really going to have to work with an attorney that knows how to do that quite well to set that up, to make sure we don't run afoul of any legal rules that exist in the state to do that. They're going to add a little bit of complexity, some asset management, but not much. And their benefits may outweigh the expenses. So let's talk about pros and cons of will. Pros: you can control property to your death. You can dictate whoever you want to get it. You can do all that with a living trust too. You can select the executor of the estate. That's the person who's going to go to court and deal with all the proceedings as we move forward. Once that property is distributed, we don't need it anymore and it goes away. What are some of the cons? Let me bring all the cons up. You got to go through probate. Probate's the process where we take the will to court. We authenticate it. That's why you go through that signing ceremony. Takes a year or longer to go through the process. We have to pay fees to the court, to attorneys to do all that to go through. Um, they're easily contested. Most wills will be drafted with a no contest clause, which basically says none of the people involved in this will or outside the will can contest it. Um, we can still contest it. There are reasons why we would let folks do it. I've seen them contested that the person did not have mental capacity, and family members were easily able to prove that based on health records. Um, This happens a lot when wills are changed as family members age and start to show dementia. That all of a sudden the will reflects that one child's going to take everything and the other children are going to be left out. Um, Typically when we see it. The other thing to point out with people contesting wills is every time a person that does that, the estate shrinks and shrinks in size because the state has to defend the will, and that comes out of the basically the bulk of the estate when it happens. So often we don't see it happen because if the estate is not big enough, no one's going to contest it because there would be no money left at the end. It takes time, and once the will is on file with the court, you only have to file a will once you pass away. You don't have to put it in register with the register of wills until then. Um, it's a very public process. Everyone can read your will at that point, and it's very state specific. Living trust, we don't got to go through probate anymore. We've taken out that whole court public proceeding. They are very difficult to contest because if you are not in the trust, you have no ability to contest it. We don't need to do anything for guardians to hold assets for minors because we already have a trust. Why might not we want to do this? There might be potential trustee fees involved. We got a family member doing this, they're probably going to say, no, we don't need to take trustee fees. If you're me and your grandma asks you to do it at Christmas because she's mad at all her daughters, and you tell her you're going to take a trustee fee after when it comes that time because you realize that you're going to have to deal with your aunts and your mother, yeah, you're going to have trustee fees at that point. And then the trust can limit what those can be, but I do not believe they can be below the statutory fee, and I can't remember what that is at the top of my head today. They're going to add a little bit of complexity to asset management, not much that would make them a problem. You just got to remember to put, property in the title of the trust and not in your own name anymore. You still got to use other estate planning tools with this. And here's my favorite thing. Even if you go through all this whole route with a living trust, you still have to have a will. Why? Because at some point you're going to buy property. You're going to forget to title it in the name of the trust. It's not going to be a part of the trust. So we just have to have a will at that point. They are literally called pour over wills. The simplest will in the world to do. It just says, whatever the terms of my trust are, this property passes according to the terms of my trust. Other documents we're going to have you do, somebody real quick, is a durable power of attorney. These are going to be where you set somebody up to handle your financial matters if you become incapacitated. Typically, we're going to need a doctor to rule that you become incapacitated. They go away once you pass away. Same idea with healthcare. We're going to have one who's going to do healthcare. Durable power of attorney is going to make business decisions. Healthcare proxy is going to make healthcare decisions for you. You want to do this. It's also going to be based on a doctor's authority that you are no longer able to make those medical decisions. The last bullet point really no longer matters, but I still leave it in there anyway, just as something to think about. In all this process, one thing I always tell people when they ask me about these is, if you are going to do this, it is always wise that in the document when you do it, no matter how fair you want to be to your children, you put one child in charge of this and state they will talk to the other children about the decisions being made before they make it. But you want to put it in the hands of one child, because if you have multiple children and they don't agree, we're going to have issues down the road. You kind of want to have one person who is the decider. The other document we're going to have you do is that advanced healthcare directive or living will. It's the set of instructions given to you, given by you in the event you can't make those decisions. It basically says when you want to be resuscitated or put on life-sustaining care in certain medical situations. It's the most depressing document you will ever read in your life. Why do we want to do this? You are the best person to make your medical decisions for you and what you want. You will want to be able to do this ahead of time. So when you can't make those decisions, you've already made them. These are also tough decisions for family members to make for you in this situation. So it's just easier to do it ahead of time. Let's quickly run through tax because I want to make sure I get done in about the next 5 minutes. So I have time for questions. Federal estate tax, it's pegged to inflation. It goes up each year. It's $15 million this year. As already said, it's coupled for couples, so it is $30 million for a couple this year. The reason it's coupled is we have portability within it. It basically means the surviving spouse can use any of the unused federal estate tax exemption that the predeceasing spouse left. All you gotta do, and when this started about 20 years ago, there were a lot of issues with the tax forms. Now most people have it down. You file the tax forms appropriately, and then the surviving spouse can never, ever, ever get remarried again because it goes away once that surviving spouse gets remarried. Maryland, it was set at $5 million 8 years ago. It is not indexed to inflation. It has not changed in 8 years. The only change made with that was they included portability within all of that. So now the surviving spouse gets the remaining ability to use that $5 million. Same rules, file some tax forms and never get remarried again. The other thing the General Assembly did prior to that was they created a special exemption for ag property. Within that, you get another $5 million as long as the property is agreed by the heirs to stay in ag for 10 years. So effectively, if you're a couple in the state of Maryland, you have $20 million in estate tax exemption if you have agricultural property. How do I come up with $20 million? You have 5 million in the regular, 5 million in the personal or in the ag side. So if you divide it up in a way, you will equally have $10 million to work amongst in that space. Some things we may think about doing, especially if we have LLCs or something where we're going to be gifting shares over or membership or corporations over, where we can give some of that ownership over, or just other property we may want to get rid of, is we can give away up to $19 million per to an individual. And that is, you can give any individual $19,000. It's unlimited in how many people you give $19,000 to. For a couple, that would be 38,000. And that is pegged to inflation and goes up to the nearest $1,000. It did not change this year. It may change next year based on inflation from this year. Anything that you go over that $19,000, it just counts against your federal estate tax exemption. So it goes down. So when the accountant does the filing, there'll be a spot where anything on the gift tax that went over, they're just going to deduct that from um, the federal estate tax exemptions. So there are strategies involved in all this if we want to give stuff away. What's the biggest issue we run into in all of this? What happens if we have a farm kid and a city kid? A kid who stayed on the farm, worked on it, helped it grow, and do that. The one thing we always have to point out is if we're looking at them together, we probably don't want to treat them equally. That's not going to be equitable to the one that stayed on the farm. We really have to start thinking about what's going to be equitable in this situation and not so much equal. There may be ways to equalize it and make it work, but we really got to start thinking about strategies to make it more equitable. Um, One way to do that, and we kind of highlighted this at the start, you could use an LLC to put it in there. The farm ownership resides with all the heirs, but the control is really given to that on-farm person. They're going to be managing it day to day with participation with the off-farm heirs. If the off-farm heirs don't want to be involved, the on-farm heir can buy them out. And there are ways within IRS tax rules to where they may be able to buy them out at a discounted rate. And they may not get their full paper value, but they'll get a value that they can agree upon, probably with the deductions that can come out. Other things we could think about: conservation easements, if there's the ability to sell those. It provides a cash influx, and we may be able to use that to equalize shares. My favorite part to talk about, because at in no point in this presentation did any gift make sense, but this gift makes sense for this thing. You've seen Monty Python and the Search for the Holy Grail. We have the father looking at his son and showing him everything and saying, "Lad, all this will be yours one day." That's pretty much sweat equity in a nutshell. We're going out, working on the farm every day. Mom and dad are telling us this will be all yours someday, and they do nothing. They don't develop a will. And now that child finds out the farm is being split among him or her and siblings. Um, all of that's not enforceable. All it does is create ill will with family members. We really do need to think about how to formalize this relationship, set across how people are going to be paid if they can be, or get the estate plan developed that creates some solutions that are enforceable. So let's talk about what happens when people get married. And I forgot to update this gift to one that actually made sense. What happens if they get married in the middle of all this? We really are going to have to start thinking about prenups to make it clear that that spouse potentially early on has no claim in the farm or business. That may change if milestones are hit every so many years that the marriage continues. They continue to gain some ability to get a claim, but early on, we wouldn't give them that claim. We may never give them the ability to make that claim, depending on how the prenup is written. And we really want to do that because we've got a plan developed. We don't want to have an outside spouse being able to ruin the plan if a divorce does happen. Attorneys like to think about stuff in terms of what could go wrong and not all the great things that could go right. The other reason we want to think about is husband and wife get married, have children from previous marriages. They have no plans to have additional children. They're older. We really want to think about how to make sure that the property goes to the families that it should be going to and have. And then I see a question: could it be done in the prenup or memorialized? I would really want it done in a prenup. You could do it in the LLC entity and the formation documents to limit it to where only family members could buy in, but I would really want to do that in a prenup just to kind of make sure it's all clear early on. Um, they have no plans to have additional children. What have I just described to you? I've described the Brady Bunch to you. We really want to have a prenup in that situation to help keep those, to make sure property goes to the right families and doesn't. And typically, the way this will be set up is and the document will be pretty simple. Anything that either spouse brought in before the marriage remains their property, and anything developed during the course of the marriage goes to all the children equally. So then we need to do this, as I point out in the presentations all the time: who has ever developed a perfect plan? And then I remind everyone a plan is only perfect on day one. Every day after that, we have situations change. We have to start thinking about how is it actually being implemented? What are the things that are going wrong? What do we need to fix? What do we need to change? How do we change that process to go about? So within this, we may have a birth, death, marriage, divorce, disability. So all reasons we want to consider changing. Buy something big, get rid of something big, have a major legal change. And honestly, we're just going to want to set aside time to do this on whatever basis you want to do it that we call regular. Is it every year we meet and talk? We may not change anything, but have a plan for how often we're going to check in to make sure everything's working out with the way we've laid out the succession. As I point out to everybody, when I first got here, the estate tax was $1 million. Then it went to $5 million. We had a lot of estate plans change because that was being done to help keep stuff in. to prevent taxes. What happens if we have an on-farm successor pass away? What happens if the on-farm successor decides they don't want to farm anymore? These are all reasons we're going to have to think about revising a plan. So to wrap all this up, all this is going to require communication to get this done. Once we do the communication and get a lot of that done, we can figure out the tools that are going to work. Alex talked on the first one about his role as a farm succession coordinator and helping, bridge the gap to where families can start working through this process and communicating. I've gone out with him on a couple to talk with him, mainly because they were going to have legal questions in that process. Once we kind of figure out what all this is going to be, we can figure out the tools that are going to be used in this process. And the other thing you got to do is, sadly, you have to go out and talk to your family. All of this was done through the Northeast Risk Management Education Center. I'm also a part of the Ag Law Education Initiative. You can find all our stuff at umaglaw.org. And I'm going to skip that. And then I put my blog in there already. And I do another blog at southernagtoday.org. It's a week daily blog with a whole bunch of marketing and other information. And then what questions do y'all have before I go to my contact info? And I'm going to stop sharing my screen. I don't know if folks want to put questions in the chat box, or you can raise your hand and I can at least.
Yeah, thanks so much for that, Paul. Do you think you'll be able to share recordings of the first two? I couldn't quite make those.
Yeah, I have the first one up and on our YouTube page, and I'm going to get this one up hopefully tomorrow.
Nice.
And then I'm still working on trying to find a version of Alex's that we did in the past.
Okay. Yeah,
So
that one
Alex
sounds
just forgot to hit record that day.
totally. No, that one sounds great. Thank you.
Yeah. Any other questions? And while y'all get your questions typed in, I'm going to put one last thing in the chat, which could have been. Bear with me 1 second. I had the page open and then it disappeared. And I will send this out as well. I just have to click on the right. I had all this open so I could do this easily. And then if folks, we have a program evaluation. If folks can do that for us, it will help us with our reporting for the grant. But if no one has, oh, go ahead.
No, I also was going to share for the benefit of the group, or Paul, have you heard the American Farmland Trust just put out a podcast called Landed? Have you heard of that? Has that
I
come
have
across your?
not.
Yeah, it basically it's very similar to what you just talked about, and it basically interviewed family farmers as they tried to navigate succession, and it was very interesting. I'm sure it's professionally relevant to you.
Yeah, I'll look that up. Thank you for sharing that.
Mm-hmm.
And since I'm seeing no questions in the chat box, if you guys can please do the evaluation and help us. That's where we're getting ideas for the next series. We do them, it will not be till 2028 the way the funding works, but we're looking at what would we do next with succession planning, and what can we do beyond the basics to do that. So yes. So thank you all for attending today, and enjoy the rest of your afternoon.